What's up, everybody? Good evening. Truth and Transparency, Wednesday night, June 18th, 2025, the same day that Karen Reed was freed. We live streamed this earlier. So, those 900 and some people that watched this live, I was there, but I was facing this way. So, well, a couple things I want to say before we get started here, which is in the case against Brian Koberger, we have 46 lab reports. Now, 46 lab reports, 11 people, Idaho State Police, 46 lab reports, 11 people either independently wrote one of those or worked on a lab report with A, another person, or B, with 3 people total. The reason I'm bringing this up first is because I want to let everybody know that I have received all 11. I went and got all 11 CVs. That is your resume. I'm going to show you those. And I'm going to show you what lab reports. There's 2 lab reports that include videos. And there's, out of the 41 lab reports. Why did I say 47 or 46? 2 of them involved 3 people, which was lab report 25, lab report 11. Then lab report 21, 1, 2, 3, and 4 all had 2 people. So I'm basically going through all the files right now I think I can probably tell you what every lab report's about based on my work that I've already done. And I'm going to reveal all that to you guys so that you guys can have it. I went through and I know everything about all these people in terms of where they from, who are the home roots, how we got this all, as this is all public information. So I'm going to have you guys look at Hector for a second here. Bring in Hector so I can play this, but let's take a look first at Hector. You guys are visual learners. Welcome to class. Okay. So as you can see, I took each person and what lab report they were part of, as you can see. Down a little bit. Down, girl. Come on, buddy. There we go. And so what I did, Rylene, check. Ayers, check. Eric Seat, check. Jade Miller, check. Ann Nord, check. Haley, check. Catherine White, check. Just like in case we have like a little Karen Reed issue. We went ahead and got these. Stephanie Wilt, check. Sarah Martinez, check. Taylor. Tina. Fuck yeah, right? Now you're probably saying, why would this be important? Oh, it matters. Okay, it definitely matters. I went through and paid attention to what these people are specialized in. Made a list and who I think is, so for example, Roots, the College of Idaho. See that? Did you know that there's a difference between the College of Idaho and the University of Idaho? We'll talk about that. Went through and I could tell you based on their credentials what part of the investigation or the lab work that they would have even been involved in. Alana, can you turn your volume up? My volume up? Usually I don't get that. Alana, can you turn your volume up? That's a first. Yeah, I'm sure I can. Let me see here. I'm going to go with the volume is fine. All right. So, Ayers, right here. I paid attention to people's backgrounds, where they're from. And Ayers, remember, Ann Taylor was like, what is Ayers going to talk about? She only produced 2 reports. That's all we wanted to talk about is Lab Report 25 and Lab Report 11. Well, Ayers is going to talk about the fact that she is an Idaho Peace Officer Standards and Training, and she does collection and preservation of evidence. She teaches this, okay? And I was looking at, so she's going to talk about, and I'm guessing breaking down the standards and what she is taught. Awesome. But if she didn't do certain things, then what does it matter what she teaches if these people didn't do it? You know what I mean? So Eric Seitz, he testified. We'll just leave it at that right now. But I wanted to point something out. I want to give it up to Jade Miller. Jade Miller worked a little bit here in Ohio with the BCI. Jade Miller. She didn't have a job there from 2009 to 2011, I noticed. And curious if she had a baby. If not, curious why she wasn't working for 2 years. I believe that Anne had something to do with the toxicology reports. Again, roots there, Eastern Washington University. I believe that's over there by Spokane. University of Idaho, Haley, as you could see. I was just trying to see where all these people came from. Catherine White. Now, she's going to be your CODIS and your lead. So Catherine White is a CODIS. She's going to be your lead with all of your, she's all your DNA girl. Okay. Tara, we're looking at her at some latent prints here. The other person that's going to be your DNA is Taylor. Tara is going to be doing latent prints. So I went ahead and gathered up all of these so we know everything about them. And I can tell you who I think has, who's going to be shaky on the stand based off of how many times they've testified, what they've testified to in the past. So that's right now what I'm working on is sorting this all out because I want to talk trial strategy and who I would most go at with certain questions. Because, for example, when I was in Delphi, one person only testified to doing the case in Delphi because they had a policy there that they don't have a bunch of people working on something because it's cross-contamination. Okay. And so I broke it all down. How many people worked on which ones, who was doing what. And when we get to these reports here that feature the multiple people, I think a lot of the earlier ones, report 1, 2, report 3, okay, these earlier reports, they got to be stuff that's from the scene. Okay. So anyways, all the other ones that are not on this page, so anything that's you don't see right here, there's only one person's name per report. But these are the only reports that have multiple people. And so I was looking through and seeing who normally is working together. Remember how all the pictures that we took from the crime scene that we took, but the media was there and we're looking at those girls and shit like that. Those are the girls that we're talking about in these. Okay. Those girls take photos. So I was looking through who had, training and experience with, some photo takers are honestly better than others. Some suck. So all of this little shit matters. And so we're going to break it all down. But I want to let everybody know that based off of the Karen Reed bullshit, I went and obtained these and got them before they could potentially disappear. They could potentially change. So, now with that said, we had a hearing for Brian Kober for third party, which is the alternate perpetrators. And we also had this motion for continuation. Now, Josh Hewitt, he did the arguing for the state, and Ann Taylor argued for the defense. We're going to watch this again. I'm going to be taking notes, but I do want to say that Joshua, he basically came out and used the words rabbit holes in his motion, that we should have a continuation so that the defense can go down all these rabbit holes. Well, that's exactly what Lally said Karen Reed's team was doing when she wanted all these people's phones that were inside the house that night. Okay. So these rabbit holes. So again, the first part of the hearing was closed. That was the alternate perpetrators. The second part was the continuation. So here we go.
Taylor, Ms. Massoff, and Ms. Barlow. This is the time set for, or at least the public portion of today's hearing is set for the motion to continue the trial filed by the defense. So we'll start with that.
Good afternoon, Your Honor. Your Honor, our motion to continue has been filed and is necessary to protect Brian Koberger's rights under the United States Constitution and the Constitution of the State of Idaho. Specifically, a continuance is necessary to protect his due process rights, his rights to a fair trial, his rights to effective assistance of counsel, rights to confrontation, Mr. Koberger's right to present a full defense, and if it should come to it, a fair sentencing hearing and to be free of cruel and unusual punishment. The record of this case spans 2.5 years, and it shows that this request does not come as a surprise. Looking through the history of this case shows that the defense has met challenges and difficulties along the way, but has been dedicated in meeting all of the deadlines. We have talked about the discovery issues in this courtroom before, and that in large part brings us to need a continuance. 68 terabytes of information is a huge amount of information. There have been 23 requests for additional discovery over the span of 2.5 years and 7 motions to compel. When I say that this doesn't come as a surprise, that this comes from the record, I would direct the court to look back to May of 2023 and June of 2023 and our second motion to compel. Included in that was what was known as Exhibit A from the defense, and that depicted how we were receiving discovery. So this is not a new issue. This is something that's been coming up for a long time. We were receiving discovery, but it was such that you would get a file that would say hundreds of photographs, hundreds of pages of reports, each having to be looked at individually to know what was there and then organized.
Okay, so I want to show you guys a clip Those of you guys that are following the Shanna Gardner case, the Shanna Gardner case is out of Florida. Jose Bias is on the ticket out there. That is a case that we are covering. Okay. I personally believe that Mario had something to do with it. Okay. I don't know if Shanna had anything to do with it. Okay. But there was fuckerage. And I said, wait a second, how would this tire end up all this months later, just waiting there for the police the day that they went to go talk to this black man, Henry Tennant? Okay. I've witnessed people false confess. We know that false confessions happen because of the Innocence Project with, DNA that will then eventually clear them. So the whole Shanna Gardner case, again, there's fuckerage going on. But right now, what ended up happening in that case is they had to continue the trial because Florida, the prosecutors, they can't even get the defense all of the discovery because there's issues getting it on like hard drives, doing this portal shit, doing this evidence share files. It's a mess. And the judge over there, who I love, Judge Kite, black woman, I think she's awesome. She's like, what the hell is going on? She's a prosecutor. What's going on here? So Mario has his own attorneys. Shanna Gardner has her attorneys, and they're getting different discoveries, or they were supposed to be charged as co-defendants. Right now, their case is not separated. I don't know if it's going to be. Regardless, it caused for the case to be pushed back. And the same thing what Ann Taylor is saying right here is when we're receiving stuff, we don't even know what it is. We got to go digging to figure out what it is, and stuff's being like in weird ways hidden, and so the reason I brought this up is because the Shanna Gardner case was continued because of that. And it just happened. We're talking like a month ago. She was supposed to go to trial in October of this year, and they're pushing that date back.
This case has also faced unique issues, starting with the media coverage of this high-profile case, non-dissemination orders that were addressed in courts, and then the grand jury materials that we had to fight to get access to before we could properly challenge the grand jury indictment. We faced issues with discovery, particularly with the IGG materials. We spent a great deal of time trying to get access to those materials. Those were ultimately what we could get, was ultimately presented in a motion to suppress, and that's preserved should there be a conviction in this case. We faced venue issues in this case, culminating in the change of venue and bringing us to Ada County. At the first hearing in this courtroom, we discussed the discovery issues and not having read everything and being ready with a full investigation in this case. That was apparent through our motions to strike the death penalty, our motions to...
Okay, so what Ann Taylor's doing right here is she's setting the record straight. People out there are saying Ann Taylor's not being hard enough, not slamming the... Ann Taylor has a list and is getting all of this stuff on record, okay? And she's going in order, okay? And so Ann Taylor is doing exactly what she's supposed to be doing. This has been an issue from the beginning because the state's comments back to Ann Taylor's motion was that they never have brought up issues and asked for a continuation until here the 11th hour. That's not true. That is so not true. Okay. So for Josh Hurwitz to say that, okay, no. And when you're, Ann Taylor's just not sitting there looking at the discovery and that's all she's been doing. So when she's going through this and reading off where our time has been spent, you know, none of this was all handed to us at once. And we've had this for the past 2.5, 3 years. Okay. That's just not the case. And we've been working on other things and we've had to fight for things to get things. We've had to fight motions and have hearings, and it's all been a step, you know, step by step by step. So I think it's interesting that Josh is actually the one that's here arguing a motion to continue based off of the past when he had nothing to do with the past and he's just joining. Where's Ashley Jennings for this argument? Where's Bill Thompson? That's who should be Bill Nye, the science guy back there, sitting back there. For Joshua Hurwitz to be arguing this motion is laughable to me because he wasn't part of any of this, in the past. Like, he just joined. So I think that it's interesting that he would even be arguing it.
Compel expert disclosures filed in September and December of 2024, and request for more time to file our motions in limine that was granted in January of 2025. Throughout the course of the motions in limine and then a motion to strike death based on discovery issues in February and March of this year, the record is replete with notice that we are not prepared to go to trial in this case. The discovery is vast and we have not had a chance to review it all. That we met deadlines for experts shows our dedication to comply with court orders.
So the reason she's making this noted is because Joshua says they've met every deadline. So there's clearly not an issue here. And Ann Taylor's like, wait, you're going to try to penalize us because we've literally worked round the clock to make these deadlines? Like, that doesn't mean shit. But he used that in his motion to say that they've met every deadline. So they can't possibly, basically this is not good cause. They've had all these resources. We've provided them, the state's provided them with, and he goes in his motion listing off all these things. So that's what was in the motion. So she's talking about this right now and listing off things that he wrote in his motion right here as to why he objects to this continuation, the state's opposition to the defendant's motion to continue. All right. So she's going in this order and saying these things based on his arguments that he presented here in the motion. Okay.
It does not depict effective counsel ready to go to trial on this case. We would submit that it's the court's responsibility to assess this motion to continue with heightened due process that's required in death penalty cases. The death penalty case is different. That comes from Ford versus Wainwright at 477 U.S. 399 at 411. The court must be sensitive to safeguard every avenue of due process. The Idaho Supreme Court said the qualitative difference between death and other penalties calls for a greater degree of reliability when death is imposed. And that comes from State versus Creech, 105 Idaho 362 at 383. Looking at all of the constitutional rights Mr. Kohberger has, effective assistance of counsel really becomes the crux of how all of these other rights are covered for Mr. Kohberger. An effective assistance of counsel applies both to the merits phase and the penalty phase of a death penalty case. The courts are guided and counsel is guided by the American Bar Association guidelines on capital cases. Wiggins versus Smith, 539 U.S. 510 at 524 said the ABA guidelines are guides to determine what is reasonable. And that's talking about reasonable performance by defense counsel in a capital case. The Ninth Circuit in Andrews versus Davis at 944 F3D 1092 at 1109 relies on the ABA guidelines as the proper measure to test an attorney's investigation. In Idaho, our public defender statutes reference the ABA guidelines as applying to indigent defense. These apply to the full investigation of the merits phase and require us to raise all legal claims. They require us to perform a background on all witnesses that might be called, especially those being called by the state.
I think that's a shout out to the DoorDash driver.
That means that we have to review all discovery to be able to present a full defense for Mr. Kohberger. We cannot present what we are not aware of. I would note for the court that discovery has been ongoing. I received discovery just this week. It is discovery that I have not reviewed yet. Considering what's required at a penalty phase in a capital case, we're required to perform in a way that the jury can carry out their function of individualized sentencing. That means that Mr. Koberger's background has to be known and investigated and ready to present to the jurors. Evidence of his character has to be known and ready to present to the jurors, and his circumstances have to be known and ready to present to the jurors. That's addressed in the Woodson case and in the Lockett case. The jury must have the opportunity to consider all evidence that may weigh against the death penalty, and that means anything from his life history. It is the duty of the defense to find and investigate all mitigating information. We do have several experts that would be ready for the mitigation portion of the case, should the case reach that phase.
That's going to be
And
the
they rely
penalty.
on understanding family history and Mr. Koberger's own history. They can only understand what they've been presented. And the investigation to fully evaluate needs to be thorough. That means that records have to be collected. That means that interviews, collateral interviews have to be done, and those have not all been completed. And it's not because of a lack of diligence in this case. Further, when things that are noted as red flags arise, those things must be investigated. Red flags aren't fanciful ideas of what else could we do in this case. They're real things that come up in the course of the investigation, and whether or not they're important to mitigation and presentation for a jury's consideration requires time to investigate and collect records. Documentation is very important. The court's aware that red flags have come up and they require further investigation. Those are issues that may mean a lot to the experts that would be ready to testify, but they can't be presented until there's a full investigation. They are things that might change the course of the evaluation or might require us to have an additional expert to help explain certain circumstances. And that's important for the individualized sentencing that's required by the Constitution. Your Honor, there have been numerous challenges with gathering records and interviewing collateral witnesses. I know the court is aware of some of those particular issues. I'm not going to highlight them now, but it's imperative that we be able to collect records and conduct interviews from other family members besides just Mr. Koberger and his parents. And it's also imperative that his history be complete with educational records, medical records, and those things are still being done to this day. The other reason that a continuance is appropriate in this case is based on the media coverage, the Dateline issue that has been talked about in this courtroom before, and what's yet to come. The Dateline episode wasn't just a one-time deal back in May. That continues to be talked about. Everything that happens in this case continues to be talked about, and this court has a duty, a responsibility to make sure that Mr. Koberger receives a fair trial. That comes from Shepard versus Maxwell, 384 U.S. 333. And a continuance may be the way that the court can best protect Mr. Koberger. That comes from Patton versus Yount, 467 U.S. 1025. In addition to what is going on with what happened with the Dateline episode, that's not all. There's a book set to be released just a few weeks from now to be followed by a docuseries on Amazon Prime. There's a claim that there's inside sources that provide information in this case. At the very least, the moment we start attempting to select a jury in this case, those things are going to be on everybody's TV, everybody's social media feed, and some of the very witnesses that will be expected to testify will be taking part in the docuseries at least, and may be noted in the book. That is in and of itself an exceptional reason for us to have a continuance to let those things play out for a while. I would also note, Your Honor, that jury selection is going to be particularly challenged and will need a great deal of time based on what's happened in the media and continues to happen.
Okay, so I want to talk about this. All right. In the Karen Reed case, they took 3 weeks to put a jury together. 3. They were allowed to go through these people's social medias. Okay. I think that this should happen in this case. All right. Hippler has assigned from January 30 or July 30th. Okay. Is when jury selection begins. Wednesday, July 30th. I don't know if he's going to be moving that to maybe Monday, July 28th, July 30th. And then the first day of trial is supposed to start on the 11th of August. Okay. That's not a lot of time if you really think about it. Going back and listening to Hippler's plan on how he's going to select this jury, okay, is night and day from what they were allowed to do for Karen Reed. Okay. So it's not even so much like we get to ask these people these questions or whatever. We want to vet their answers. You know what I mean? We want to so I'm curious to know if they're going to have access to these people's social medias. I think that they should. Okay. I think that they should be able to go through their social medias. I mean, obviously, you know who they are. And then, I mean, who does the investigating into that? Like, hey, who's this person, and see who their families are. And then you're going to go through whoever their family is to see okay, are they diehard fucking Idaho4, consumers? So it's when Josh argues in his motion to say that that's what the voir dire is for, and we're going to be able to weed out these people, right? Well, I mean, I would say yes and no. You are, if you're able to vet them and take the time needed to, Bev at least allowed that with the jury selection process taking 3 weeks. I get the vibe here. He's not a slop tart, the judge, but he is definitely a time person where it's like, you're going to only have X amount of time. So at the very least, I think both sides should have, and not just the defense, this is both sides, to vet who's ever going to be potentially on this jury, that they have the ability to vet their social medias and who their close family and friends would be. And I'm not a fan of sequestered juries until they get the case, and then I think that they should be sequestered. But I mean, can you imagine being sequestered for a 3-month trial? I mean, I don't want anybody like that on my jury. Like, God, get me out of here. I just want to go home type of thing. You know what I mean? I just think that they should be sequestered once they get the case. That way they're not talking to anybody else during the time that they're then allowed to talk. So for me, it's more finding out who the leak was. That way you can use it in court, because it's a knock on that person's credibility on why they would ever leak it, what the motive was, and to be able to be used against them. I don't think so. That's way more important to me than we're going to just push this down the road because something came out on television. Fuck that. I don't want to push this. How have we not discovered the leak? How have we not discovered the leak yet? I think the person should be asked on the stand why and who they leak stuff to, why they did it, if Karen Reed's statements in an interview can be played in little clips, okay? The person, whoever did this leak and gave out Brian Kohlberger's Cellbrite download, like, and so I want to know if Ann Taylor makes that push to say, the prosecution's asking me for a date on when would you be ready to go? Well, when are you guys going to solve the who leaked everything? I'll be ready to go when the leak's solved. How about that? What's going on with the leak?
Your Honor, our request is for a continuance in this matter to allow us to be effective and perform our constitutional duty for Mr. Koberger, to protect his constitutional rights, to make sure that we have fully investigated all mitigating circumstances so the jury, if it comes to it, can perform their individualized sentencing, judgment, and function, and to allow some space between what's recently happened in the media. Thank you.
All right, let's see how he's saying Joshua gets up there.
Yeah, Your Honor. Of course.
Again, total slap in the face to Ashley Jennings, Bill Thompson, Bill Nye, the science guy back there, Mr. Nye. Okay. All these people that have been on the case since day one. Look who's getting up there. Why? Why does this dude have to get up there and talk? Who's this dude? Oh, you guys don't know who this is? Right there next to them, by the way, that's a Hector. Right there, that little arm thing. They call it, I think, Elmo, but that's a Hector. Ashley Jennings, no fucks given. I wonder if she was on Zoom. Again, the leaker can only be law enforcement. Okay? The leaker can only be somebody that was part of the non-dissemination. Okay? And why I say it can only be law enforcement is because nobody else should have had Brian's cell phone. It's all right.
Thank you, Your Honor. I will, I think, address Ms. Taylor's argument sort of in the reverse order in which she raised the issues that she raised. I want to begin, though, by bringing us and the court back to what the standard is for this motion to continue as opposed to what might happen after a conviction with respect to ineffective assistance of counsel. Right now, the standard is whether denying a continuance would violate the defendant's rights by causing unfair prejudice. And that is an objective standard that the court has, and the court has discretion on all motions to continue, including a motion to continue in a case such as this that involves the death penalty. What the defendant and counsel are asking the court to do is delay this trial because of their subjective, prospective beliefs about how an ineffective assistance of counsel evaluation would happen by an appeals court if there is a conviction. What this court should do is use its discretion and look at the objective record. The record supports denying the motion based on what the defense has been doing, continues to do, and will continue to do through the mitigation phase until the penalty phase, including presenting mitigation evidence that the jury will ultimately decide about if there is a conviction. The lens that the court should look at is well stated, through which the court should look at this motion is well stated in some Idaho case law and others. And if I can turn on the Elmo.
Oh, it's the Elmo. I
Do I
told
need
you
to hit
guys.
this button, Your Honor?
Clerk
Okay,
needs
good.
to switch it over.
Okay, thank
It's
you.
the Elmo.
So these are cases that we cited in our brief, and I
He's-
wanted to start my discussion with them. I'll read the top case, which is an Idaho Supreme Court case, evaluating whether counsel was effective in a death penalty case. Counsel was not required to investigate defendant's entire life in order to objectively and reasonably present mitigation evidence. And then
We got a PowerPoint lover. You guys, we've been doing this for how long with this case? Never once has Ashley Jennings or Bill Thompson used an exhibit ever in a motion hearing. Joshua, first thing he does, we got a PowerPoint lover. Oh my God. I wonder how do I feel about this? Interesting.
I like the way that the Seventh Circuit sort of rephrased the same principle by saying, I won't read the entire quote, Your Honor, but a scorch the earth strategy is not required. We're in a standard of reasonableness.
Okay.
And the record that is before the court, and I'll acknowledge we have not seen what specifics, if any, the defense has put forward. And
Okay, the reason he says that we have not seen anything, just so we're clear, there was an ex parte hearing where Ann Taylor presented a bunch of shit to the judge, okay, and the state could not see it. The state was not a fan of it. Judge Hippler overruled on their objection to all of that crap and let the ex parte communication happen and did not provide it to the prosecutors. So that's what he's referring to right here. When he's like, we haven't even seen what they've presented to you. He also says that he doesn't know if they're asking for more time because of the mitigating stage, which is the penalty, or if it's for the merit stage, which is the guilt phase. We're unclear of what are you asking for? Is it because you need to, is it time with the guilt? And I don't know how he's confused. Okay. It's clearly for both. Obviously, I mean, the Dateline argument has nothing to do with the penalty phase. I mean, come on. That's has everything to do the impact for the guilt. I mean, so to write an motion and say that it's unclear if they need the continuance because of the penalty part or the guilt, the actual trial. That's just asinine.
and it's ex parte filing.
It's kind of hard for you, I recognize.
It's gaslighting.
It does, but we have not seen specifics. I did not hear any specifics from counsel just now about these witnesses need to be contacted. These records need to be.
So he's basically saying Ann Taylor's being vague.
Obtained.
Kind of like that PCA, huh?
And then the court, I think, mentioned at prior hearing we had when this was motion to continue was first raised, that the court would be looking at what admissible evidence the defense needs to obtain and what strategies would actually be used to fruitfully obtain that evidence. And we don't have anything specific that we can respond to about that. So I'm at a bit of a disadvantage, Your Honor, but I think the record that we do have shows that the court can use its discretion to deny this motion to continue. What we did in our response brief, Your Honor, was to cite the fact that the defense has identified 55 defense witnesses for mitigation, and I think one was recently added, so we're up to 56, 132 exhibits to use at the mitigation phase. And with respect to the ABA standards, we're not saying the court should completely ignore them, but what we are saying is that the court should look at them for what they are, which is a retrospective tool for appellate courts to look at the performance of counsel after conviction, not some checklist that needs to be religiously adhered to in order to actually get to trial. Even if the court were to rely on them heavily, though, the charts that we put together showed that for each of the ABA guidelines categories that the defense has raised, we have seen evidence in the record that shows that they have witnesses to talk about those issues and they have discovery on those issues themselves. Now, defense has called that superficial, but we would ask the court to look at the tables and look at the witnesses that we've been able to identify for each category and also the discovery in the record. So, Your Honor, again, we think that given the legal standards here on a motion to continue, given the court's discretion, given that we are in a world where the court needs to satisfy itself that defense has done a reasonable job to prepare for trial, there is no basis for a motion to continue.
How does
Now, let me turn to some of the specific arguments, and I can take this down, Your Honor, that Ms. Taylor raised.
Okay.
With respect to the media coverage,
Okay.
we acknowledge, as the court has, that will pose challenges for jury selection. The issue, though, is not whether there is a lot of publicity. We know there's going to be a lot of publicity regardless of when this trial happens. As Ms. Taylor said,
I would agree.
people will continue to talk about this case.
I agree 100%, 150%. Okay. So I totally agree with that. Okay. I want the trial to actually happen when it's planned to happen. I think that it's time, but we're not privy to see what Ann Taylor, like, she's being vague with her stuff because she's allowed to be vague because she's already disclosed it to the court ex parte. So we don't know what that all entails. I know that a lot of it has to do with the mitigating phase, and then the other part of it has to do with the third party.
The issue is whether the court, using the procedures it has established, or maybe even modifying them as the court wants to, can seat a panel of impartial jurors. The Supreme Court of Idaho has found that despite widespread publicity, even on the day of jury selection, that is possible. That is possible in this case, despite the challenges.
I don't think he can argue that. Wait. So
In this case, despite the challenge, and a panel of impartial jurors. The Supreme Court of Idaho has found that despite widespread publicity, even on the day of jury selection, that is possible. That is possible in this case, despite the challenges. The other thing I would mention with respect to the publicity is that it puts us at the whim of the media. Every time there's a breaking story, every time there's a new book or a new documentary, are we going to continue the trial indefinitely? And that seems to be the danger in what the defense is asking for. We call it a perpetual continuance, and we haven't seen a proposal about when this trial could take place. If there's a continuance, what seems to be the strategy here is just to delay. And that leads me to, I think, the other point that Ms. Taylor raised, which was to say that, this shouldn't be a surprise. It is a surprise to us that a motion to continue was made so late in the game, after, by the way, the trial date was used to oppose an extension that we filed for with respect to our mental health expert. At that point, the defense said we can't possibly go down this road or give the government the state what it wants because of the trial date. Once that issue is resolved, then we get a motion to continue. So I think what we have seen from the defense is that they tried to use the mass amount of discovery to remove the death penalty from the table. When that failed, now we have a motion to continue. So I do think timing is relevant.
So basically he's saying that this is not brought in good faith. Okay. And now here, I would be making these notes, and this is how I would be taking what he's saying, is that without saying what I just said, that's what he's accusing. Okay. That basically us asking for a continuation is not in good faith. Okay. And so I get a chance to, and hopefully Ann Taylor has a chance to combat what he's about, what he's saying, because now this is where I dig in about Dateline and saying it's about the leak, Your Honor. Who leaked this? Because I want to cross-examine them. I know that it came from law enforcement. We did not even have Brian's phone until this date, Your Honor. This is when we were given the discovery. This date right here. This is the first day that Dateline ever produced something, and it was before we got his phone. Here are the date of the discovery. Here's the date that I was given a mirror image of Brian's, his cell bright. That didn't happen until way after Dateline had their shit. So you can say that we're out here to delay. Well, you're out here to ambush. You can say that we have all these Mydrid, like I have 3, lawyers with me. I have 2 investigators. What are 2 investigators? 2 investigators for all the shit that they have? 2 people to go through that shit? 2 investigators, Jay, and then who you see at the table. I'm sorry, but how many fucking people have they put at that table? Look at 1, 2, 3, 4 just sitting there. Ashley Jennings was 5. Okay. And then they were using the whole 80. They were using the Attorney General's office, and Ann Taylor had to put a motion about that. Like, who's trying this case? Who's trying this case?
Here. Again, and it's not just that the defense waited so long, it's that we now have a very substantial record on which the court can deny this motion based on everything that's been put in front of the state and the court. In terms of the mitigation investigation, Your Honor, Ann
Taylor says it in her motion. She says, you guys are going to come with this story, okay? We're going to be coming. We're not just here to poke holes at your shit. We're citing case law, and we're coming with our own story. Kind of like what Karen Reed did, okay? Karen Reed didn't just poke holes at the witnesses that got up on the stand. Karen Reed said that John O'Keefe was bit by a fucking dog, okay? And not that it wasn't me, meaning Karen Reed didn't hit him with the car. He wasn't hit by a car, okay? The defense is coming with, and she says it, with a story, only because he used the word story, like a narrative, okay? The defense is not just combating this with cross-examination of their witnesses. The defense is set up to have a defense. Third-party culprits is what Karen Reed, okay? Same thing here. They call it alternative perpetrators. It's the same thing, just 2 different names.
believed, but did not have confirmation that the defense had a mitigation specialist until the reply brief on this motion alluded to an affidavit that mitigation specialist submitted. So I don't know what that says. I don't know what the mitigation specialist has said, but the fact that there is a mitigation specialist, apart from the 3 attorneys and 2 investigators that are part of the defense team, that person has one role, as I understand it, which is to prepare for the penalty phase if we get there. And that person, that specialist, has still time to continue doing whatever work they told the court they need to do. Your Honor, again, I would try to get back to the record and ask the court to look at the objective record when evaluating this motion. 55 mitigation witnesses, over 100.
Why does he keep saying the objective record versus just saying the record, buddy? Let's get back to the record. What he's saying there is, let's get back to the docket. And if we follow the docket down, that Ann Taylor has never been asking for more time, a continuance. She's never tried to do this before. Why are you doing it at the 11th hour? They've had, they have all these people. They have all these experts, and they never went to the resource manager here. I couldn't even believe this argument. Don't know if he brings it up here, but the defendant's legal resources have been more than adequate. Defendant has 3 trial attorneys, including a lead attorney who has represented him from day one, 2 investigators, and the assistance of at least one additional public defender. He also has engaged an outside mitigation specialist to assist in obtaining materials for use during the penalty phase. This record reflects that the defense team has been working hard for defendant and, as explained below, has met the professional standards for the defense of a death penalty case. So just because somebody's working hard, they should be punished, according to Josh. If I'm, hey, just because we're working hard, so should we just not work hard and we wouldn't get through a bunch of shit? Should have missed deadlines and then we would be entitled to shit? I mean, I think that, I'm sorry, me personally, like, that argument blows dick. Okay, just because somebody's busting their ass, you're going to try to use that as a, really? He says, this record reflects that the defense team has been working hard for the defendant and, as explained below, has met the professional standards for the defense of a death penalty case. Well, that's funny, because if you go ask people out there, they think the defense team sucks. Yet defendant still claims that the court is, quote unquote, cutting off his review of discovery. Yeah, you're cutting off our review of discovery because we were supposed to have everything by September 8th of 2024. It is June 18th of 2025, and I just got something at the beginning of the week. That's almost a year after the deadline. And you want to know what the state's argument is? I guarantee you, is they're asking us for stuff that has zero relevance in this case. Yet the defendant still claims that the court is cutting off this review of discovery. This is unfounded. Defendant's attorneys have had sufficient time to review discovery and have not established any discovery violations by the state. No. They've discovered discovery violations. There's just been nothing that's happened from the judge. They've discovered things. There's just been, like, that's not even true. Because the one I can just rip off right here, right now, is the violation of the big problems surrounding the lab's standards and protocols that got hidden somehow and wasn't put into the camera review. And remember that? Oh, voila. Oh, I didn't realize that the, Idaho State Police has had it the whole time. 7 motions to compel. And remember, the state on numerous times kept saying, we don't have to give you that. We don't have to give you that. We don't have to give you that. Oh, is it because you had Ashley Jennings doing stuff and it's considered work product because she's a lawyer, but she was doing police work? Is it because Bill Thompson was doing the same thing? They fucked around for so long. All right. It's like we were trying to get all this stuff and took all this time to get all this stuff. And now we're trying to break it all down. And I don't think that we should be penalized. So that's the argument from the state, is that if you would have just given all the stuff from the beginning, he says they have been able to identify over 1,000 exhibits and nearly 200 witnesses for this trial. Indeed, the court also recently admonished the defendant's counsel to seek additional resources from the resource judge if they needed more assistance to review discovery and prepare for trial. The defendant has not claimed that he sought more resources and was denied. Neither the size of his legal team nor the need to continue the review discovery from a valid basis for a continuance.
.30 exhibits, a very robust team on the defense side, which includes their retained experts. Ms. Taylor, and in the briefing, really honed in on this idea of a social life history for the defendant. I don't know if the court has read the expert reports of the defendant's forensic psychiatrist and then the licensed psychologist.
Just 5.
I won't discuss the details in open court, but our position is that both of those specialists, well-trained, very experienced specialists,
They revealed his social and medical history, and he was diagnosed with autism, OCD, and ADHD. Collectively, these experts took a deep dive into the defendant's entire life, including by interviewing his family, teachers, coworkers, and even a psychologist who evaluated defendant as a child.
conducted significant, fulsome life history investigations. They weren't just looking at bare records. They were talking to people from the defendant's past, from his present, his family, and developed parallel life histories. And in their reports, as I read them, no red flags that needed further investigation were noted. Nothing about those reports appeared to be incomplete. And the experts didn't say, we are unable to reach the conclusions we need to reach for lack of investigation. So I think that is sort of proof in the pudding. We have a life history for the defendant. The defense has amassed significant materials. And I thought we were going to be solely talking about the mitigation case that still needs to be developed. That is not a basis for a continuance. And to the extent there are ongoing discovery from the state that Ms. Taylor alluded to, I can represent that most of what was just turned over was our investigators speaking with witnesses that the defense has disclosed. So that's the nature of that discovery, is us responding to discovery from the defense. And that will continue, of course, to occur as we lead up to trial and witnesses make statements that we need to disclose to the defense. So with that, Your Honor, I would.
Okay, so what that is right there, that's very interesting. So it's based off of the witness lists, okay, when they had to exchange these witness lists. Then Ann Taylor put together, hey, we need any interviews that you did with all these witnesses. We need any of, your interviews, your reports, anything that you did with the witnesses. Because let's be honest, guys, nobody goes to trial and you don't talk to somebody that you're putting on your witness list, okay? So the defense is entitled to any interviews that would have happened with any of the witnesses that the state has put down on their list, okay? That's what he's referring to there. And I wonder if Ann's saying, no, we definitely asked for other things besides that.
Again, rest on the case law holding that a scorched the earth investigation is not what's required. And on the record before the court should exercise its discretion to deny the motion. If the court has any questions, I'm happy to answer those. Otherwise, we would submit on the record before the court.
Thank you.
Thank you.
Any reply?
Oh, hell yeah. Any reply?
I would start with noting that if the new discovery is the state's contact of witnesses we've listed, the state knows that there are mitigation witnesses that we've listed because we had to disclose them, but they are people that have refused to speak with us. That presents a challenge in the case. A lot of the witnesses that refuse to speak with us have to do with records, medical records of Brian Koberger, past treatment records of Brian Koberger.
Why?
Those are important things that the gravity of what they have to say can't be known to our experts until we have the opportunity to fully understand those things. And we continue to work on access to witnesses and access to additional information.
Okay, that's interesting.
Your Honor, I want to touch on just a couple of points. One, when the court considers a continuance and considers whether Brian Koberger's rights are violated, his right to a fair trial, his right to confront witnesses and evidence against him, his right to present a full defense, and his right to effective assistance of counsel are implicated and laid out in our motion to continue. The ABA guidelines require us to do a full investigation. It's not going scorched earth to understand Brian Koberger's full life history. These are things that are required. And we've done everything that we can. We have had a mitigation expert on the case. This is 2.5 years into a case, and the average for capital cases is 3.5 years
That's true.
in federal court.
Which moves at a snail's pace in its best day in regular cases.
I'm not a practitioner in federal court, so I don't have any basis to talk to the court about that. But what I can tell you is that a capital case where we have a client and we need to investigate both the merits phase and a penalty phase at the same time takes time. In any case, it takes time to do that. In this case, with the high-profile nature and having people decline to talk to us presents a whole set of challenges that we have to find a way to work through. As the court knows, a lot of mitigation information is very sensitive information. It takes some time to be able to get people to talk about things. Realities exist too. Not all of the family members are in the same place. So there's travel that's required. All of those things take time to do in a case like this. 2.5 years is excessively fast to put all of that together. There was no delay in having a mitigation expert on board. There was no delay in getting investigators to work on the case. And as soon as issues became apparent, Mr. Koberger's team did not delay in getting experts to help us understand specific areas of the case. Looking over the entire record, the court can see that the defense team has been diligent about discovery, about motion practice, about litigating issues in the case. There just still is a lot left to do. There is still a lot left that is not known. And Mr. Koberger has a right to go to trial with prepared counsel that have conducted a full investigation in both phases of the case. When you have a certain amount of information and there's this other stuff that's out there, that's a red flag, that's real, that you need to investigate, your experts can only do what's here, what's been investigated, what's been produced for them to assess. This whole other area, that land between the red flags and the investigation, that's an unknown area. That's where there's ineffective assistance of counsel. That's where there's not a fair trial. That's where there's not an individualized sentencing proceeding. And it's that area that requires a continuance in this case.
I think this is interesting that Anne's not even I would have taken a Dateline shot just about the leak, about you want us to go to trial, then I guess I'm going to ask everybody if they
All right, I'll take the matter under advisement.
I bet you will.
Opinion out in short order.
He will. He'll have it out this week.
In the meantime, I fully encourage everyone to continue as if the trial is going to take place when it is scheduled for. Again, I reserve the right to write the decision that I come to, but as of now, I would tell you that it's likely you're going to trial on the date indicated. All right, is there any other matters that we need to take up in the public session before we break to go to the private session?
Wait, so they did the public session first? You would have thought that they were so flat because they just oral argued about stuff for, an hour and a half before that. What a bunch of flat fucks. They need land up in this bitch. Woo! Wake up, motherfucker! Karen Reed, baby. Coming off that high still.
Nothing further in the public session, Your Honor.
No, Your Honor, I don't believe so.
All right, we'll take a 10-minute break while the
That was me. We don't drop our standards, motherfuckers. You around here, you listen to this shit. All right. Woo. So he's going to take that under advisement. I mean,
bailiffs clear the courtroom and we set up for the private session.
go to the courtroom. Get these people out of here. Get these people out of here. What a day. I have a couple clips I want to show you guys to show you guys just how ridiculous crap is out there. Let's go like this. Okay. Let's see. Mm, okay, you guys. Who is this creator? Look at.
Hey guys, in this video we are going to go over a body cam footage, a video of a woman who was allegedly the DoorDash driver.
Okay. Her name, Lana Marie. That's my motherfucking name, bitch. Get this up.
Relevant to the Idaho4 unalivings. This happened in Pullman last year in 2020.
Look at Lana Marie. Who is that? That's my name. Look at that beautiful ring to it. God, do they just want to be like me or what? Is this person real? Is she real? Or I thought it was AI. You guys, I thought it was AI. Oh, this is even better. That's wild. All right, all the Maries out there, high five. Okay. Anyways, yeah. She is real. Oh, see. Woo! That's awesome. I thought it was an AI channel. I was like, wait a second. Wait. That is awesome. That is fucking priceless. All right. I want to show you guys this. Okay. You know we got to go to this. Okay. Now. What do we got?
Trial. And if you thought things couldn't look any worse for Brian Kohberger with, the DNA and the cell phone, things are only 55 days away from the opening statements in the Idaho quadruple murder trial. And if you thought things couldn't look any worse for Brian Kohberger with, the DNA and the cell phone data and the surveillance video.
By the way, did you guys see my bombshell episode? UC Davis did the sheath. It says that it was secondary transfer with those type of numbers. Thought that was crazy. Wait, this is bad for Brian? Oh my God.
and an eyewitness description of his eyebrows, at least, not to mention the laughable alibi. I like stargazing at 4 o'clock in the morning with my phone turned off. I know, I kind of thought that too, until what I heard today. A smoking gun that both sides somehow managed to keep under wraps for months. There is apparently another eyewitness.
Oh my God. Oh my God. How can people be on such, like, how can I see it one way? Like, oh my God, what a train wreck we have here. Okay. And all you people see it the same way as I do. And mainstream media comes out here and says that this is a smoking gun. Molly McMichael is a smoking gun. Guys.
It's the DoorDash driver who delivered food to Xana Kernodle less than 10 minutes before Xana and her boyfriend Ethan Chapin and Xana's housemates Maddie Mogan and Kaylee Gonzalez were all savagely murdered by an intruder. Police have confirmed to us that a woman seen in some of the interrogation footage from an unrelated incident.
Police confirmed this to you, so they're leaking more shit? Oh my God. Wait a second. Wait a second. You guys, did you hear this part? Police aren't supposed to be saying anything. Police have confirmed to us. Do these people want to be called in?
Is a 43-year-old woman known only as MM in the court documents. She was arrested that day for a DUI while being questioned at the Pullman, Washington police station. Just happened to reveal to the officers that she had to, quote, testify in a big murder case here because I'm the DoorDash driver, end quote. When the officer asks which murder case.
Which murder case? Which murder case? Because that officer was like, she's lying. Oh, this should be good. Which murder case?
The woman says, quote, the murder case with the college girls. I'm the DoorDash driver. I saw Brian there. I parked right next to him, end quote.
She is such a liar. You guys, then when did the DoorDash driver get there? They think this is a smoking gun. It actually, her saying those words, Brian wasn't there yet. Remember Brian's supposedly coming at like 406, 407 doing 3-point turns? You guys. This would actually prove that who were you actually sitting next to? Who's actually the killer? I know, this is hilarious. You guys, Ashley Banfield would be one of those jurors in the deliberating room, not understanding that or I should say she'd be one of the free Karen readers, or not the free Karen readers, but the anti-Karen readers that's saying, how do you know what's on the DUI, Lana? Like, how do you know that? That's process of elimination. It's like, I don't know, deduction. It's logical. It's like reasoning. It's like, I don't mean what's right here. In order for us to continue all the way down to number 5, we have to say not guilty, not guilty, not guilty, not guilty to get to that part. Or we're not even talking about this OVI or whatever you want to call it, DUI. Huh? Oh my God. The DoorDash driver was just parked next to Brian. You're telling me that their eyewitness has managed to rack up 2 DUIs within 9 months of each other, when she should probably be in, I don't know, witness protection. As this would be bombshellish, right? Like, whoa, right? Wow, God, these people. She ain't no eyewitness. Actually, if she is, and if she's gonna say all that, then there's a problem with that 407 car.
And I think I need to read that last part again because I did a double take when I first saw it. I saw Brian there, she says. I parked right next to him. That interrogation video was posted on a YouTube account where it was discovered by web sleuths and journalists. It's unclear, though, whether the woman's
She called me a
outing
journalist.
will affect the start date of the trial itself. The defense has been pushing for a delay for weeks now, but that's over the media leaks, the whole Dateline episode kerfuffle. And that is due to be the subject of a big hearing tomorrow. But the prosecutors want the trial to stay on target for the planned August 11th beginning. Our senior national correspondent, Brian Enton, is in Boise, Idaho tonight with much more on what all of this means. First of all, I did not see this coming, a second eyewitness.
Yeah, this is a bombshell, Ashley. If it is true what this DoorDash driver is saying, then this is a bombshell. I came to Boise thinking that the hearing tomorrow was going to be the big story, but this is big. The Idaho Statesman was the first to break it today. Basically, this DoorDash driver, who we knew existed, by the way, we've known for a long time there was a DoorDash driver that she...
Wait, what? The Idaho Statesman did what? God, they all suck each other off. It's a suck fest, suck and blow. Can't wait to get my fucking happy ass down there. Let's go, motherfuckers.
She goes by MM. She's been referenced in the court documents. We knew that she arrived there to deliver DoorDash at 4 a.m., about 10 minutes or so before the murders. But what we didn't know is what is in this body camera video. And let me explain this a little bit. You did, Ashley, but the reason we know about...
Do you guys hear them on national television admitting to the timeline being completely fucked now? Unbelievable. So unbelievable that I went and pulled the DoorDash 403 records, 404 records that they wanted. DoorDash records for Xana and Ethan. AVW or 000265 contains Ethan's DoorDash records, but not the records for Xana. The 4/5/2023 disclosure is a DoorDash search warrant return. The warrant returns contain photographs, a list of deliveries to 1122 King Road, and span as far back as 2019, and a spreadsheet of communication between the person ordering the food and the DoorDasher. The state has not specified which of these records it intends to use at trial, how they were made and kept in the course of a regular conducted business activity, and if it was regular practice of that business to make that report or record. Remember, this means that the state tried to pull off in both files they provided it was just Ethan's DoorDash records. It was the defense saying, where's Xana's records? You know, the person who ordered the DoorDash, allegedly, supposedly, or if somebody else ordered it, or if it was, you know, however you went about this, but you didn't even provide us with Xana's, and you're trying to act like that file was that, like 000852.
This is because last year, this DoorDash driver, totally unrelated to the Brian Kohberger case, she got pulled over, suspected of driving under the influence. She had a expired tag, suspected of being...
She got pulled over in June as well, in 2022, right before the murders, okay? And the vehicle that she was in then had expired, the registration, there was no registration, okay?
under prescription pills, and she got pulled over in her case. She got pulled over, suspected of driving under the influence. She had a expired tag, suspected of being under prescription pills, and she got pulled over, and she just started volunteering this information to the police while she was being interviewed, and it's on body cam. And she said that she's the DoorDash driver from the Brian Koberger case, that she saw Brian Koberger.
She didn't say she saw Brian Kohlberger, motherfucker. She said she saw Brian. Number one. She never said I saw Brian Kohlberger.
Which is really the headline here, that she's a witness who saw Brian Koberger, and all of this just happened to come out through this new body camera video from Pullman, Washington.
So, Brian, you take us back to the house. But we're going to have to describe it because the house has been torn down. But if you look at the front of the house, there's a parking lot out front where all the cars were lined up, and they stayed that way till they were all towed. But this DoorDash driver said, I parked next to him, which makes me wonder if she's talking about the parking lot out front, or if she's talking about that side street off to the left where that bushy tree is, that big tall bushy.
Do you see the sick spin? Oh my God, Ashley. Now you know that she fucked the timeline up by what she said. That now Ashley's coming to the rescue and trying to change the words, change the meaning of the words of the witness. You are sick, man. This is so fucking sick. I love it. I love it though, because we are witnessing this in real time. The spin, the mainstream media propaganda. Oh my God. Oh my God. This is priceless. I don't love it because odds that Brian gets killed is so high. Gets killed? What are you talking about gets killed? Nobody's getting killed. Who's getting killed? Gets killed. All this shit is only going to help somebody. If they're truly innocent, this shit is only going to help Brian Kohlberger. Trust me. I mean, wow. Ashley Banfield knew exactly what she needed to come on and say to this is priceless.
There's a parking lot out front where all the cars were lined up, and they stayed that way till they were all towed. But this DoorDash driver said, I parked next to him, which makes me wonder if she's talking about the parking lot out front, or if she's talking about that side street off to the left where that bushy tree is, that big tall bushy tree is just adjacent to the red car there. Because there's a side street that goes up that left-hand side of the house, and isn't it
Yeah, it's a very
believed that the killer used? Yeah. Walk me through that.
Sorry, I didn't mean to interrupt you. There was someone talking in my ear. Yeah, it's a very, very important part of what she said. Not only that she said, I saw Brian Kohlberger, but I wrote this down. She said, I parked right next to him. Now, you think about DoorDash. We all order DoorDash. A DoorDash driver typically would park right in front of the house where they're delivering the food. They'd pull into the driveway. You see them in the
DoorDash drivers don't usually pull into your driveway, by the way.
driveway, they get out, they go to the front door, they give the customer the food. Why would the DoorDash driver drive onto the side street of the house, which with the murder house, you've got the front of the house, you've got the driveway like you described it, but then you've got this side road that goes up the side near an apartment building. You can't even walk down to the house like through, you'd have to go through the woods unless you walked all the way around if you went to the side road. We don't know exactly where
Remember I went over this with all of you people? Remember I said, thank God I can have these videos. Okay, listen. Back in the day when you would actually type in 1122 King Road, okay? The way that it designs you, remember I said that it has, the GPS would take you to make a right, and it would want you to walk through the woods, and it had like the little dots. And I walked us through that. I said, look at this. I said, that car looks like the damn DoorDash driver. Okay. the person that's doing this loop-de-loop 3-point turn and shit, okay? We are on the hunt right now for the record. We are on the hunt to find out all the cars that Molly McMichael would have had access to by friends, okay? Their little friend circle. We've already went through, I don't even know, 60 some vehicles. But that vehicle is literally doing somebody passing something up and following something. Okay, now think about it, if it's Molly. Fuck, you know that she's a fart in the wind, man. She'd get lost, you know. So she's trying to find. That looks like the door. That looks like a DoorDash driver. Does it not? Does to me. That person that's that 40 whatever number, and making the 406, 407 3-point turn and shit like that. But that's what they're saying is a suspect vehicle car. If Molly says that she parked next to Brian Kohlberger, they got problems. They're going to be able to show that video. Molly, isn't this what you said to officers? That dash cam's coming into evidence. They think this is a bombshell for this is how they're trying to spin it, that, oh my God, we got to get in front of this and say how, oh my God, there's this second. Who's the first witness that saw Brian Kohlberger? How about that? The second witness. Who's the fucking first? Oh, Dylan? Dude, nobody saw him. They're saying this is the second because they're saying Dylan's the first. This is the second eyewitness. I mean, this is insanity. But you know what? This is mainstream media, baby. This is what they do. This is
parked, you know, if he's guilty of all this. They've never said that in any of the documents. We know that he's caught on camera going up there and going up towards the house, but we don't know exactly where he parked. But if she's saying that she parked right next to him, does that mean that he parked right in front of the house, that he just pulled right in the driveway and then went in for about 10 minutes to commit these murders? We don't know, but it's certainly interesting to think about.
Well, no, we know that. I mean, he doesn't. Do these people not pay attention to the documents? The car that they said that the FBI has and is using the lights with. Okay, they're saying that car goes and shuts off the lights, like it turns off the lights and it's parked back in the back area in Queen. Okay, how do you not know this, Brian Enton? How do you not know where the murder car is parked? It's in every document that fucking mattered. It's the FBI's report. They're saying that the car, nobody parked out in front here. Nobody parked out in front there. The state's case is that the person who committed the murder parked back because you couldn't see the illuminating lights. Okay, because they were using the 1112 camera to see, okay, yeah, you see how the lights, okay, now we can't see the lights anymore. And then now, poof, we have this speeding a car. Like, that car was up there that everybody's talking about, the 406, 407 car. That goes up and parks behind Queen. Great, the storm's rolling in. Perfect. Oh my God. Let's just pull out front and run out with fucking knives and all black ski masks, man. Dude, this is just I thought they were following this case. Dude, my coverage is going to crush them. You know, I've been having to juggle, like, at the time I've been covering the Idaho4 case, I was covering a lot of other cases. All right. Now it's full blast mode of getting everything prepped and ready for how I'm going to be able to deliver this unbiased coverage. Because trust me, doesn't matter if you're a state witness or if you're a defense witness, I'm calling it as I see it. And when there's shit that's going up there and it's bad for Brian or good for Brian or makes people look like fools or it makes people look great, it is what it is. Okay. I'm going to call it if it's a fair trial. Hey, look at that call by the judge. Da, 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 da. We're here for the purpose to make sure that our constitutional rights stay intact, right? And that's not going to be by covering a case in some fucking bubble. All right. It's going to be by getting the facts right. And right here, these people don't have the facts right. Unbelievable. Unbelievable. So
that's what I wondered. And then also, just with the pictures we're looking at now, again, I'm always so sad when I see those cars parked out front behind the yellow police tape, because it's sort of the vehicle's frozen in time from the kids who would never come back to use their own vehicles until their parents or their loved ones took those vehicles away. But it certainly doesn't look like there's a whole lot of room, which made me wonder if this DoorDash driver parked out front on the street, knowing, well, I can't go into this little parking lot. I'm just going to have to park out here on the street, which now would can't DoorDash driver this little park. It certainly doesn't.
I can't go into this little parking lot. I mean, I've been there. That's not a little parking lot. You guys look at it right there. I have all the cameras of us with in September of 2022. You would be able to pull right behind any one of those cars. There's all that space. Okay, if you couldn't find a spot, like this is where a DoorDasher would pull right behind either the Range Rover or Xana's. Okay, unless there was other vehicles there at the time, then you couldn't do it. But right there's plenty. That's a ton of cars could park right behind those, like 1, 2. Then you have to get that police car out of there, so you'd be able to put. There's a ton of room. After you would try to just because at first you're trying to find even what vehicle or what house it is, and I'm going to show you guys that clip, because you can't find it anymore because they fucked with Google shit, but you can if you had the old shit. And so if anybody needs it out there, we have the old clip of what the GPS did back then. And that's what matters is how you can show something on what the GPS did back then. And when you went to this house and you pumped it in, it brought you up to the left side here, and it wanted you to walk through the woods, basically, on the side of the house to get to the house. That's what the GPS told you to do. I have it recorded. It's like that car that we see at 406, 407. It's doing this. It's doing exactly what I would expect somebody to do that's trying to find a place, not even trying to find a parking spot. It's trying to find where they're delivering food.
Doesn't look like there's a whole lot of room, which made me wonder if this DoorDash driver parked out front on the street, knowing, well, I can't go into this little parking lot. I'm just going to have to park out here on the street, which now would make a little more sense.
This little parking lot. I mean, do these people? That's a delusional sentence. After you are just showing the parking lot, and then it's not little, you say this little parking. I mean, that's just fucking delusional. Delusional.
Sense if Brian Kohberger did this, if he's really the killer, he might be surveilling
that little
from
parking
a little
lot
farther away, not
the
so
driveway,
obvious,
actually,
and out on the street. But that's the only thing I can think of, because as you said,
little.
Going up that side road, it's really hard to get access to the house. As a DoorDash driver, you just wouldn't go up that side road to the side of the house.
Yeah, the whole thing up there is tight and confusing. The layout when you drive up.
If you're following a GPS, you would, because it tells you to turn right. I mean,
there is very, very strange and tight. We would always have a hard time finding a place to park up there. There's a little bit of parking on the street there, but it's difficult. It's hard to get in there. So there's a place where maybe a DoorDash driver could have just pulled off without going fully into the driveway and like put their flashers on and run up with the food. But it's hard to imagine that Brian Kohberger just parked right in front of the house. I have to say, I'm a little skeptical.
Good job, Brian Enton.
Of this whole story.
Oh,
just the way that it came out.
Then
through
wait
the
a
body
second.
camera
Wait a
video.
second. Then why are you calling it a bombshell if you're skeptical of it? What the fuck is going on? You guys, we have a bombshell. 5 minutes later. Guys, but I'm really skeptical of this. So we have a lie shell. I mean, how does anybody watch this shit and not get totally fucking confused? I thought this was a bombshell. I'm totally, in that parking lot's little. I do believe that Molly was in a vehicle with somebody that night and that they were door dashing. I 100% believe it. I do. But guess what? We don't have to believe it because Ashley Banfield went and asked and got confirmation from the police. The police told her that, yep, that's true. That's what it says at the beginning of this little show. So that'd be like another leak. You're not if somebody asks you a question about this case, you're not supposed to say anything. Okay, I'm at the 7:26 mark. Okay, I just want to make sure that I'm correct in that statement.
In the Idaho quadruple murder trial, and if you thought things couldn't look any worse for Brian Kohberger with, the DNA and the cell phone data and the surveillance video and an eyewitness description of his eyebrows, at least, not to mention the laughable alibi, I like stargazing at 4 o'clock in the morning with my phone turned off. I know, I kind of thought that too, until what I heard today. A smoking gun that both sides somehow managed to keep under wraps for months.
Smoking.
There is apparently another eyewitness. It's the DoorDash driver who delivered food to Xana Kernodle less than 10 minutes before Xana and her boyfriend Ethan Chapin and Xana's housemates Maddie Mogan and Kaylee Gonzalez were all savagely murdered by an intruder. Police have confirmed to us that a woman seen in some of the interrogation footage from an unrelated incident is a 43-year-old woman known only as MM in the court documents. She was arrested that day for a DUI while being questioned at the Pullman, Washington police station. Just happened to reveal to the officers that she had to, quote...
Wait, so you had somebody type it all up like that so you can make it seem like a police officer? Oh, she's only confirmed as MM in the court documents. It's all we're able to say. That's why I went back. Look at how she's reading off a prompt. And so they took time to strategically type that up like that. People are sick as fuck, man. I don't need no fucking prompt right here. Suck on them. Absolutely ridiculous.
Of this whole story, just the way that it came out
You're absolutely
through
welcome.
the body camera video, the fact that in all of the police documents that we've been able to see in the probable cause, we knew there was a DoorDash driver, Ashley, but if they had a real credible witness who saw Brian Kohberger at the house, that is huge. How would we not know that by now? It's possible it's just like a bombshell that they're saving for the trial, but don't you think maybe that would have been in the probable cause or
Maybe.
in all these court hearings that we've been to where we get new little nuggets? I would have thought maybe
Instead of lying in the probable cause.
I can't believe that it wasn't even a whisper rumor. You're right, especially with all the reporters that descended upon the story.
Did she just say whisper rumor? I love when people get my mind in the right place at the right time. Whisper song. God, that's all I can think about right now. Boom. 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 Boom.
Story, finding every DoorDash driver in town. I know that we try to reach every DoorDash driver in town, but the problem is everybody, does side hustles with DoorDash. So it could have been anybody. And that was the problem with actually trying to find the person who did deliver the food that night. Okay, the question about this person in particular, MM, the woman in particular who's, told the police, I'm the one who's going to have to testify in this case. I'm the DoorDash driver. I can't imagine what it's like to be her, because she had nothing to do with any of this. I'm sure she wants nothing to do with any of this. Like, the stress and the frustration that this would have brought to her life, I'm sure, is unthinkable. But she also may have the credibility issues, especially if there's a DUI in play, or, you know, drinking.
2. But there's a lot more than that. You're going to have to go back and check it out. How was her life difficult? Nobody knew about it until she spilled her guts. That female officer with the glasses, Heidi Lambley, who was part of the Brent Kapaka saga, okay?
And she seemed to say on the body cam, it isn't the first time.
Yeah, and look, I feel terrible for her too, Ash.
I do.
I mean, the fact that we've confirmed she is the DoorDash driver, and she was there at 4 a.m. just...
Wait, what? We've confirmed. How did they confirm this? So that's why I went back to listen to the beginning, because I wanted to hear it. And in the beginning, all it said is, and she strategically wrote this out this way. She read off a prompt and is that we got confirmation from the police that MM is the DoorDash driver. That's not the same thing as saying Molly is the DoorDash driver, McMichael. Molly McMichael brings the drug world into the picture, ladies and gentlemen. Okay. Molly McMichael brings the drug world into the picture in this case. I think that there was a small sliver of a chance that the state wasn't even going to use Molly McMichael. Just because it's in the probable cause doesn't mean the state has to use it. You understand? And I think that the state was not going to use it. I'm telling you, I don't think the state was going to use her. That's why I think that there's a small sliver of a chance, okay, that this leaked very interestingly, okay? And when I say leaked, it's been out there. This happened in September. She spilled her guts to WSU, okay? Pullman Police. There was a guy out there that put it out on his channel 8 months ago. Not fucking Kevin Fixler from the Idaho Statesman. That is not who stumbled upon this. Like, fuck, man. That's not even true. Unless you're saying that the Idaho Statesman, holy shit, is anonymous X-Man video dude. Oh my God, did you just out that? Oh my God. Holy shit, they just outed the video guy. Oh my God, that makes so much sense. Holy shit, Kevin Fixler's YouTube channel is fucking the anonymous guide channel. That whatever, it's the anonymous whatever, the officer channel. You're like, I love when Leanna has a fucking brain moment. The Axon video, yes. Yes, bitches. Yes, motherfuckers. Yes. I'm over here saying, why are they saying that Kevin Fixler did? The Idaho Statesman broke it first. No, 8 months ago it was, and I was like, oh wait, unless that's his channel. I was waiting for you to figure Fixler out. I figured him out. That's his channel then. Damn.
Minutes before this brutal slaughter happened. That's a hard thing to deal with, I'm sure. And I feel very, very sorry for this woman. But in terms of credibility, I've seen the body camera video. She's pulled over. She's horrible for her too, Ash. I mean, the fact that we've confirmed she is the DoorDash driver, and she was there at 4 a.m. just minutes before this brutal slaughter happened. That's a hard thing to deal with, I'm sure. And I feel very, very sorry for this woman. But in terms of credibility, I've seen the body camera video. She's pulled over, she's crying, she's had DUI in the past. They take her back to the station. She's emotional, she's distraught, and she says, and she's just telling this cop that I'm the witness from the Brian Kohberger case. I'm the DoorDash driver. I saw Brian. I parked right next to him. I'm just wondering, was she was really the DoorDash driver, but like maybe she thinks that she parked right next to him, but it wasn't actually him. I don't know. I just think about the credibility. And I go back to the point that how is this the first time we're hearing this story? And it's through this means, through a body camera video that's totally unrelated of this woman in a very, very desperate situation after she gets pulled over for DUI.
So what do you think just in terms of this hearing tomorrow? Look, like you said, your focus was all about the Dateline leaks and how the defense was just sort of apoplectic about how this information got out from under the gag. Now there's this, and it's out there. It's not a leak. It's just, people put things together. Is this going to have an effect potentially on tomorrow's hearing and the issue at hand, which is a delay in the upcoming August start?
Oh yeah, he can come on. We can plan it.
I don't think so. I suspect this will not come up at the hearing. I do think it's going to be a bombshell hearing. I think it's going to be a really interesting, juicy hearing. I think that the judge is going to have to hear both sides about whether they want to delay. And
Why did he think this was? I knew that hearing was going to be boring as fuck. Number one. Why would you think it was going to be juicy? What? Okay. Wow. Holy shit.
I think he'll probably make a decision because they've already filed their briefs with their reasoning. But what I'm more interested in is at the last hearing, Ashley, you remember, he talked about wanting to bring on a special prosecutor to do an investigation to sniff out who the leaker is within law enforcement and figure out who leaked that information to Dateline. I think we're going to get an update on that. Are they going to bring in a special prosecutor now to have, could there be criminal charges? Have they figured out who this person is? They may have even figured it out by now. I'm very interested in all of that, which is gonna come out at this hearing tomorrow, Ashley.
Have you been, and listen, everything in this case has been difficult to learn, but have you heard any rumblings of an investigation already? Like, have they been ferreting out who's spoken with whom? Have they confiscated cell phones and that sort of kind of, I hate to even suggest it, but asking people within the investigative circle, hand over your phones or we'll subpoena them and we'll search your history?
Well, we know that they asked everyone involved in the case and everyone in law enforcement involved in the case to save all of the records in their cell phones and emails so that they could go back and try to figure out who this leaker is. In terms of how the investigation has progressed, we don't know. That doesn't surprise me, though. I mean, this judge is serious, and he was serious before, and people were nervous to speak up before. I'll tell you, after the last hearing, I don't think we're going to know anything about that investigation. I think people are nervous, which is why I think it's going to be interesting tomorrow to finally find out what's been going on behind the scenes here.
So how do you feel about? How do you feel about what you heard in that hearing?
Trial because of this ongoing investigation into the leaker.
Wow.
Wait, you know what's crazy? Is it these two know who's supplied them with shit? Come on, man. Have you been called, Ashley? I haven't been called. No one's been I've never asked anybody for anything. Shit, to this day, I still haven't played the 911 call on my channel because I refuse to. I have integrity. Say whatever the fuck you want about me. Oh, I don't like Lana. Well, then I guess you don't like the truth. I guess that you don't like searching for it. And I guess you just Whatever's being told to you, you just swallow it. That's not what investigative journalism is. And I cannot believe that the bombshell, that the smoking gun, the 911 call not happening for 8 hours, that's the smoking gun. That's a smoking gun for a non-guilty verdict due to reasonable doubt. A 911 call not happening for 8 or 9 hours when you're going to have the same type of like a ARCA expert come in and show you how the scene has been cleaned, how it's been staged. Okay. You want to talk about smoking guns for reasonable doubt. All right. Lana has played the call. I have not played the call. I have not played the call on my live 911 call. So wanted to end with that. I did supply you guys with I separated. If you guys haven't seen, I did a live that says here, I'll show you guys. Go check it out. The reason I did the live was to break it down because people are visual learners. So if you've not seen the live where you can catch Dylan and Bethany's phones being separated, and on one side I did, so here it is. I'll share it with you guys. Again, go check it out. Boom. You want to take, so I separated, here's Bethany's call detail records on the left, Dylan's is on the right. And if it's green to green, that means it's when Dylan, oh, did it not share? Oopsies. Okay, did it share now? Okay, there you go. Where you see green to green, that's Dylan and Bethany communicating. And then where you see it's blue, all right, if it's gray, you can see that if you look all the way to the right, it has just like DoorDash delivery, supposedly 3-point turn SUV, or not SUV, suspect vehicle 1, the thud. So 4:19 and 7 seconds. BF called DM. I'm sorry, if it's blue to blue, they're communicating. If it's green, it means one of them is doing something. But when it's blue to blue, it's their interaction, Bethany and Dylan. And if it's down here, and this is where the interesting part happens. But yeah, so I separated it. Everything over here is what Dylan Mortenson's doing from the Cellbrite extraction and what Bethany Funk is doing. And when you actually look at it in this way and you can see what's going on, it's interesting that they would not be on the phone and doing anything that was at least revealed to us, because it goes way more in depth, but 3:51 until 4:19. Okay. As you can see, there's no phone activity for either one of them from what we've been given. And that would include also the gray space. See, 3:51 to 4:19. And then can you imagine that all that stuff supposedly happening and that you wait until immediately after the supposed person was allegedly like gone, that's when that would happen? And then I was able to show you guys that there was no overlapping. Okay. I found it really interesting that these two girls, if you're working together to try to figure out what's going on in your home, Okay. You would be at no point in time, based off of the evidence that we have, can you see that they were doing something at the same time. And it's like if I was on the phone with you and it was like, okay, I'm going to call this person and you're going to call that person, you know. But go check it out. I did a breakdown. It was a couple lives back, and I think it'll help you understand when it's separated and how important certain vehicles and that Linda Lane camera footage can be. But I just don't think there's any evidence out there that shows that the vehicle that left at 4:20 that we see on the camera, how you're able to say that that vehicle is the vehicle that came at 4:06, you know, and doing the 3-point turn, then coming back up, how you're able to say that that car is the 4:20 car, you can't. And the jury is going to see that. And that's just what I think is going to be mind blowing. Is because, like, how are you saying that that vehicle is that vehicle? How are you saying that the car that's speeding away is the 406 car? Like, you're just saying that. You know, like there's you can't tell what car the 420 car is. Like nothing. So, but me and Pavarotti, we're gonna do a live for you guys. I think it's about time that we do that. I think everybody would enjoy it. So, with that said, I submit on the day. It's just, you know, I was going to bring up tonight. Another live that I had scheduled. I'm not even going to give Proctor's airspace with the 2020 interview that he did. I think 2020 can kiss my fucking ass. ABC, how in the world do you go and Karen Reed was freed today, and you take the day that she was freed and you put out an interview that you did with disgraced Michael fucking Proctor on Karen Reed's fucking day that she's finally freed of these bastards that have literally like framed her, that you're going to air that shit on this day. That's no integrity, man. I get it. You need to make money. You got the interview. Great. You can't put that shit out, I don't know, Friday. I don't know, like today. Fuck all that. That's what no class and that's what no integrity means in my book. So I just, and I had it scheduled tonight to talk about it at 9:30, and here I'm still at 9:56. I'm going live tomorrow morning for the post Karen Reed. I can't just like let people just boom. Our 9 a.m. Session has to just come to a close. No, it deserves a bang out. So maybe that's where it needs to be discussed. But I'm not going to take Karen Reed's day away from her and talk about that fucking piece of shit. So I'm going to push that back. I made that decision kind of when I started this live, like right before I went on. I was like, you know what, this is Karen Reed's day. I'm just so happy for her family. So, but 2020 interviewed the disgraced ex-trooper Proctor, who called not only Karen Reed all those names, but that ignorant, disrespectful piece of shit called Scorty Bello, who's the medical examiner, a whack job cunt. And so I want to know if that asshole that interviewed had the balls to ask him about that. That man has, he should have been fired. I'm glad he's fired. He won't get another job and I think it's great. I know that a lot of people are probably giving him money under the table, and I love it. I love that he has to take the handouts. Do I feel bad for his kids? There's consequences. All kids should learn about that. So your dad is facing his consequence for what he did. So, but do I wish ill upon any of them? No. Do I want them to die or anything like that? Fuck no. It's, hey, you make your bed, you lay in it. Do I want his kids to be amazing human beings and go on and do great things? Absolutely. Those are kids. They have nothing to do with anything. But no, just because you have kids doesn't mean that you're not held accountable for what you did. And so his wife can go out there and make money, and he can stay home and, I don't know, fluff the fucking tables and put pledge on the and cook food and do whatever the fuck. But and his kids can, and nobody should do anything to those kids. Nobody should say anything to those kids. It was that man and that man alone. So anybody that does anything like that, that's fucking whack, crazy, and you're part of the problem too. So cheers. Love you all. A great day. And that DoorDash is anything but a side or a thorn in anyone's side, except for the states. That's a problem that the state has now. That's a huge problem for the state, not anybody else. Yeah, he can put on a fucking, yep, he can go, yep. Yeah. All right, guys, thank you so much. Moderators, thank you. Free Karen Reed. Cheers.